Good evening. We're happy to welcome you to the third webinar of our Legal English webinar series dedicated to legal writing with Dr. Heather Weger, Associate Teaching Professor. My name is Angelina Kondratьева. I teach Legal English at Legal English Center, St. Petersburg, and tonight I will be facilitating this seminar and helping Heather. Our webinar will consist of two parts. The first part will be theoretical and it will last approximately 40 minutes. Then the second part will be practical and it will start at 8:15, and it will be for a smaller group of participants, those who have signed up for it and those who have received a Zoom link via email. Though the materials for this part, for the practical part of the session, are not going to be recorded, you're welcome to find the materials on our website at legalenglishcenter.com. So we hope very much that you find this third session as informative and as helpful as the previous ones. In fact, we have no doubts about it because we have Dr. Heather Weger with us. So Heather, hello, will you please take the floor?
Thank you so much. I appreciate that kind and warm welcome. So as we jump into tonight's series, I welcome back all of you who have tuned in to earlier sessions and also welcome any newcomers that are with us. I am a linguist. I am not a lawyer, but I do teach at a law center in a major U.S. city. And I have been working with legal writing for the last 7 or 8 years, and I've been in the English education sphere for over 20 years. And so I'm excited to talk with you tonight about what insights a linguist can bring to the space of legal writing. You see pictures of my kids on the screen, and I show them in part because similar to the way that children go about growing up, when we are becoming legal writers, we go through an analogous process of growing up in our skills. And today we are going to explore the next questions in how this growing up process works. The first of the questions is merely to think about what we talked about in our first and second webinars and how they're related to what we're going to focus on today. And that primary question for today is to explore how legal English writers demonstrate legal points. I'm going to walk you through several examples that show you how laws have been birthed and raised in the U.S. system and how that process has created an expected path for how writers should demonstrate their legal logic in order to be convincing. What you will leave today's session with is an understanding of how definitions are a critical tool for legal analysis. So I want to take us back now to a quick review of what we've already covered. And I began the story of the legal writer with a focus on the legal reader. As seen in this quote here, written recently in 2024, this is still a prominent part of legal English education and the underlying theory of legal writing. And that is that there is a silent conversation that the writer and reader are having. The writer understands how the reader is thinking. And based on what that process looks like, the writer that is successful learns how to communicate with it, how to converse with it. So what we are using to discover what the reader is thinking is the tool of genre analysis, which comes from my field of linguistics. So in that first webinar, we tried to explore, I tried to convince you that it is really the reader who is setting the expectations for what counts as effective writing in legal English. And I introduced you to the tool of genre analysis as the way we would go about thinking of these expectations. In the second webinar, our focus shifted from the reader to who is doing the writing, right? So who the writer is and what the writer's decisions are as they go about the fundamental task of integrating law into the written text. We looked at the who, and we looked primarily at writers for court documents or the creators of court documents. So we were really focused on writing that happens in and around the court system. We had not yet really looked at who writes the statutes. So that's our jumping off point for tonight. The simple answer, it's not a simple answer, but the simple answer to start with is that legislative bodies via Congress write the statutes. That can be at the federal level, and that is also true at the state level. This is actually a rather complex story, and I'm going to break it down into the next four sessions of our webinar series, including tonight's focus, which is on definitions. Okay, here we go. Why am I going to focus with you on the idea of the statute? And that is because the statute is actually ambiguous. I'm not the only one who says this. The field understands this here in the legal U.S. context, that it is not as simple and as straightforward as it might be in other legal systems. There are many reasons why ambiguity arises around statutes, and these include the inconsistent ways that different writers list the definitions. And by this I mean that you can find definitions in different parts of a statute. So there's not one place to go in a statute to see a list of all of the definitions that are relevant in that context. Also, there are sometimes unusual definitions for ordinary words. This might be because we have a set of ordinary words, but they have a special or unique meaning when we look at them through the eyes of the law. Also, different definitions for the same term can occur in different statutes or even within the same statute. So we have to be careful about which statute we're choosing and how terms are defined even within specific components of one statute. And also, courts don't consider only the words of the statute, but they consider the intent. What was it that the writers of the statute were trying to achieve? And these are different aspects that lead to statutes being ambiguous in the U.S. context. Why does this process create this ambiguity? Why is it that the legal writers and the legislative bodies aren't able to eliminate the ambiguity? And it's really because it's inherent in the way the system works or doesn't work, depending on your perspective, right? Bill drafting is not done in one consistent way, and it's not coordinated across all of the different people and bodies that are in charge of creating the statutes. They're discussed on the floor of the Congress, information is added, taken out, and there's no one authority that oversees this process, so it leads to different meanings bubbling up in different places. So what I'm going to do, if I haven't convinced you just by showing you these statements and explaining it a bit, is that I'm going to try to convince you of what type of ambiguity there is, because you might be thinking, oh, come on, it can't be that bad. But I think I can prove to you that it is. All right, so here we go. I have a little pop quiz that you guys out there are going to take, and I'm going to walk you through the setup before you put your answers in the chat box. But everyone out there, wake up. You're about to put some information into the chat box. First, I want you to prepare your mind. What image do you see in your mind when you think of any of these three words? Just choose one. A street, a vehicle, surprise. Some of these are concrete objects like street, vehicle. Surprise is a more abstract concept, right? But in your mind, what do you see when you have that word in your mind? Now, how can you represent with words what these words mean? Right? Is it possible to represent with words what these words mean, right? So you might, for example, be looking at, hold on one second, my screen is being blocked here. There we go. You might imagine a picture of a word street. That one's kind of easy to see in your mind's eye. Also, you might think of a vehicle. You could draw a picture, but you could also give a list of examples, like is a motorcycle a vehicle? Is someone who is using a wheelchair, driving a wheelchair down a street, is that considered a vehicle? My mother loves to mow her lawn. What if she were to ride her lawnmower to the grocery store? Would that be a vehicle? So you could make a list of different things that count as a vehicle. Another way to approach this is to try to describe the word, and that might be appropriate for something like surprise. Like, how do we really indicate what surprise is? So for your pop quiz, I'm going to show you some images. And when I show you the images, I want you to try to match the image to the word, okay? And here's a hint. I have 3 words, and all 3 words do, in fact, match one of the images, right? So all 3 words have a match. And one word even might have 2 matches, okay? All right, so here we go. This is our first picture. What you're seeing here is some water, and there's this long expanse of wood where a person could go, or maybe a bicycle or roller skates might be used. In the second picture, you might recognize this as a rather famous expression for a painting of a famous expression. This third image looks like something my child might have drawn. She's 6. Here is another image, also similarly drawn by my daughter. And then we have this image of this woman with this expression on her face. So take a moment as the pictures have come up. You can pop in the chat box and give you a moment. Which of these is street? Which of these is vehicle? Which of these is surprise? Okay, hopefully you've popped in a few answers out there. And I'm going to try to convince you that this is why statutes in the US are considered ambiguous. The first word that I'm going to tackle is the word wharf. Did you know that a wharf is a street? Well, sometimes. It depends on what you're looking at. So we have an administrative code of New York City, and it uses the term street in 2 different locations of the same statute, of the same code. And in one place, you will see that streets include wharfs. But in a different area of the same statute, streets include many things except a road within a park or a wharf. So it is explicitly included under one category and explicitly excluded in a different category. So let's think about what the word means in the law. We have to look at more than just a statute to figure out what the words mean in particular uses. Here we're going to take a look at the picture of the plane. When is a plane a motor vehicle? When you first thought of what a vehicle was, I'm going to guess that most of you did not think of an airplane, right? Well, the U.S. Supreme Court also ruled that airplanes are not motor vehicles. But let's see how we got there. First, in 1919, a man stole a plane, and he flew that plane from one state to a different state. He was arrested and he was convicted. According to the National Motor Vehicle Theft Act, even though the term airplane was not included, the court determined that it was the intent of the statute to include airplanes. So the man was found guilty, and he appealed that decision. When he appealed the decision, the court said, yep, nope, we agree. Even though you appealed, this second court also believe that the airplane counts under this statute. The man appealed again, this time going all the way to the Supreme Court. And the Supreme Court said, you know what? An airplane is not a motor vehicle. And if you look into the case, what you see is a reliance on the fact that the statute did include a discrete list of things that were considered to be motor vehicles, and airplane was not in that list. And the Supreme Court decided that, given that airplanes existed at the time that the statute was written, had they intended for it to include airplanes, they would have written that into the statute. Ergo, they decided the man is not guilty, and he went free. The government was ultimately unhappy with that rationale, and it took some 50 years, 60 years, that they then reversed that or changed the statute, which would then explicitly include aircraft as well as language to allow any future development of other types of vehicles that are yet to be known. So they tried to close this loophole. So when we are tracing what words mean in the law, we can't just look at the statute, we have to look at the cases. Whenever a legislature enacts a statute, we don't understand what the words of the statute mean until the court tells us. And what the court tells us is then binding on future courts. So if we were to rely on the decision of the Supreme Court in 1931, airplanes were not considered to be a part of the National Motor Vehicle Theft Act. Any decisions between 1931 up until 2006 would have had to determine the same outcome. But once we got to 2006 and the statute was changed, then we could begin the cycle again to see what future decisions would happen. So there is an interplay between how a statute is written and how the courts are actually also writing the law. Now, there are two different strategies that you can use when you are referring to definitions of legal terms when you're writing. The strategy that we're going to look at here is when you explicitly signal that you are using a definition, and we're going to explore whether these definitions are coming from the statute, which is one type of U.S. law, or from a court decision, which is another type of U.S. law. Right, so those are the two types: U.S. law from the statute, U.S. law from court decisions. Okay. All right, so here in the example I have on the screen, you can see I've highlighted the phrase commercial activity. Commercial activity is not something you can hold in your hand. It is abstract, and it needs to be defined, and it is defined, and the writer clearly indicates that through the is defined and as. Our questions that we can talk about, first, one of them is purely mechanical. Why do we have quotation marks around the phrase commercial activity? And in legal writing, you can use the quotation marks to indicate a direct quote, but you can also use the quotation marks to indicate the word of focus or the legal term of art. So here it is more that it is a legal term of art, although it is, of course, an actual direct quote. It is a term that is used in the law. Is the definition found in a statute, or is the definition found in a judge-written case law? And is the definition a direct quote or a paraphrase? So I'm going to give you two little quizzes. This is going to be the first one, and then you can try the second one on your own. All right. So here we go with the first one. Is the definition found in a statute or a judge-written case law? All right. It is actually found in a statute. I've highlighted that in blue. It's called the Foreign Services Immunity Act of 1976. That is a statute in the U.S. Right? And then it is a direct quote. You can see that because the definition is found in the quotation marks, either a regular course of commercial conduct or a particular commercial transaction or act, so forth and so on. We talked about last week the id, the ID. So the id that you are seeing several times in this paragraph is constantly referring us back to the law of that statute. So everything that we're seeing here is a statute, direct quote coming from that statute. All right, now it's your turn to practice. I'm giving you another definition. It has been explicitly signaled because we have that the courts have defined official act as, right? And to give you the context for this paragraph, they're talking about the federal bribery statute. Okay, the federal bribery statute. It has a part of that statute that says there is an intent to influence any official act. So what I want us to focus on in this next 60 seconds for this example is not the federal bribery statute, but how official act is being defined. What counts as an official act, what isn't an official act. Okay, so this is our situation and our context, and I've got the two questions. If you're brave, type out your answer into the chat box. Looking at the paragraph, do you think that this definition is coming from a statute? Do you think this definition is coming from a judge-written case law? And another question you can think about, do you see the definition as a direct quote, or has the writer paraphrased the definition? Right. So for those of you who are fast readers, you might already be popping your answer into the chat box. I'm going to read it out for you to give you another moment to think.
Well, Heather, I must say we have quite a group of active people here, so who are sending us messages, right? And
actually, wonderful. Let's hear what they have to say.
Yes, so there were quite a few people who actually commented on matching exercise, vehicles, and the words, and they got absolutely correct answers, right?
Okay.
And now, so the answer is it's a statute, it's a direct quote, paraphrasing, so from case law. So these are the answers that I can see now in our Telegram channel.
Hey, well, you guys are your speedy thinkers out there. Of course you are, because you're lawyers, right? I do hear some right and wrong answers here. I was hoping that the fact that we're in the federal bribery statute would not confuse you, but in a way I did want it to confuse you. The statute defines bribery, but the statute does not define what official act is, right? The official act is found in cases, and there are 3 cases that have been cited here to paraphrase what counts as an official act. So one paraphrase is coming from U.S. versus Sun Diamond Growers. There's another paraphrase coming from McDonald v. U.S., and then the final one is the U.S. v. Brewster. Right? When you look at all of the sentences around those citations, none of them have quotation marks. So the writer is paraphrasing how the court defined what constitutes an official act. Okay. So in some, you can see either a direct quote or a paraphrase. Like sometimes it's coming from a statute, but some definitions are not found in the statutes. The only place that we find the definition is in the case law.
Yes, so and there were a few correct answers about that.
Wonderful. Yes. The case law is not an example of the law. The case is the law. It tells us what the definitions are. Okay. All right. I'm going to move on now to, I've got 2. Is this my last one or is this my? Okay. Okay. So I have one more sort of deep dig into a definition. So before we take that final deep dig, checking our time here. Oh, we're doing good. Do we have other questions or thoughts? One question I have for you. Oh, go ahead. I'm sorry.
No, just some more comments like judge written, paraphrase, judge written or case law. So people agree on that. So it's a case law, and that is a paraphrase.
Good. One where we're headed towards our last moments together, so you can begin to think about your reactions to this question and already putting it into the chat box if you'd like, which is how cases and statutes function similarly or differently for the legal writing that you do or in the legal system that you are in. So I will want us to end by thinking about how this process differs or is similar to the process that you experience. The final example that we're going to go through here is to take a look at how the law distinguishes between forming a contract and amending a contract. So if you are a contract writer and you were disappointed last week because none of the examples came from a contract, the primary example from today is in the space of when there are disputes over a contract. So we're going to start with what the statute stated. There is a statute from the state of New York that's called the Uniform Commercial Code. And in that code, what I have here in the orange is the relevant legal term that we're going to talk about. Right? So it says the additional terms are to be construed as proposals for addition to the contract unless. Right? Additional terms are to be construed as proposals for addition. That means to amend. Not part of the formation of the contract, but rather it's an amendment to an already established contract. So if new terms are brought up between the parties that have already formed the contract and new terms are proposed, they must be evaluated as additional terms, as amendments, right? Unless they materially alter. Right? They're going to become terms of the contract unless they materially alter it. If they materially alter the conditions, then they're not automatically going to become part of the contract. They're going to have to be renegotiated. Right? So when we think about what that really looks like, we can give the statute a thumbs up because it is telling us what is the important term that we must determine, that we must define, and that's whether there's any material alteration. Does anyone see a definition for what it means to materially alter the terms of a contract? If you read 1, 2, and 3, there's no definition for what it means to materially alter it. But the statute realized this, and so it added a comment, right? And when it added the comment, we're going to figure out what is a part of this idea of material alteration, right? So ways for us to think about this is, what does materially alter mean? What actions materially alter a contract? Or what actions are in or out of the scope of a material alteration to a contract, right? So if someone proposes a new term and you don't like it, it is automatically going to become part of the contract unless you can prove that this new term materially alters the original contract, right? That's going to be your job. That's the only way you're going to get out of it, right? So thank you for telling us that, dear statute, but what does that mean? So the statute added a comment, and in that comment, it specified that material alter is an action that results in surprise or hardship. Results in surprise or hardship. So now, what do you think the next logical question is? What is surprise or what is hardship? Has the statute defined that? No. The statute doesn't tell us what counts as surprise. Right? So then, to find out how the law defines surprise, and this isn't how it defines surprise for everything, but how it defines surprise in the issue of contract negotiations or contract amendments or contract disputes, right? We have to look at a case. There's no other statute to help us. So the case that we can find is one called Bayway Refining Company versus Ogden. It doesn't matter, right? It's a case. They had two merchants. The merchants had a dispute, and the way that the merchant could dispute the term that they did not like was to prove surprise. So let's look at how this happened in the case. So we see, first of all, that we have material alteration. It's being defined, and that definition is a direct quote, and it's coming from the statute. Later, we see in the case where the writer of the case is telling us a definition for surprise. This writer says surprise must satisfy two elements, and then goes on to explain what those two elements are. Okay, so in order to determine if your client does or does not meet the element of surprise, you can't look at the statute. You must look at how has this case defined what surprise is. And that's what you have to help your client with. So when we look at how this ended up in another case, right? So now we have the statute for part of our definition. We have a case for the second part of our definition. And then our third example here is going to put the two of them together. I'm going to read the excerpt out loud, and I want you to listen for a few things. First, I want you to listen for what words you see being defined, where the source of the definition is. So is it coming from a statute or a case? And if you feel that the definitions are direct quotes or paraphrases. Okay. So a material alteration is one that would result in surprise or hardship if incorporated without express awareness by the other party. And we have not one, but two citations. Surprise includes both a subjective element of what a party actually knew and an objective element of what a party should have known. And we have the id. We have stated that a profession of surprise and raised eyebrows are not enough. Citation. Instead, to carry its burden, the non-assenting party must establish that under the circumstances, it cannot be presumed that a reasonable merchant would have consented to the additional term. So this legal writer is grappling with multiple levels of definition. And I'm curious what our listeners out there are saying or thinking, how they're responding to any of these questions.
Yes, we have one more definition of a surprise here. So it is from Ivan. Surprise is something unexpected and out of scope of the contract.
So out of the scope of the contract, right?
Yes.
Something unexpected.
Surprise is something unexpected and out of the scope of the contract.
Yes, unexpected and out of the scope. When you look at this paragraph that I'm showing you here, do you see this idea of being unexpected? It's a very good observation that has been made. Right? And you'll see it in the last part of the paragraph. It cannot be presumed that a reasonable merchant would have consented to the additional term. So I want to link that phrase with this idea of it's unexpected. So then, because I've been trying to think like a U.S. lawyer, when I see unexpected, the next question is, well, what is something that's unexpected, right? And here it would be, it's unexpected if a reasonable merchant it's unexpected if a reasonable merchant would not have consented, right? It is expected if a reasonable merchant would have consented, right? So let's pick it apart a bit.
Okay, if I can, we have one more observation here from Mariana. The source of the definition is the Uniform Commercial Code.
Yes. Good. So we see it in material alteration, just as Maria's commented. It highlighted in blue is the statute. That's where it's coming from, right? It is a direct quote, but there is also a second citation there, right? So the legal writer in a U.S. context needs to both cite to the statute and then needs to cite to a case that shows that that is the way the statute has been, that is the correct way to interpret the statute, right? So we have both the blue statute and the green, which I'm using to indicate a case. If we look further, then we can talk about the word surprise. And surprise includes two elements, subjective and objective. And we can even begin to see that the writer is giving us some definitions of what it means to be subjective and what it means to be objective. Right? Subjective being what a party actually knew, the facts. Did you or did you not know this information, yes or no? But it's not enough to say, oh, I did not know about this, right? That doesn't count as surprise by itself. It has to also meet an objective element of what a party should have known. And that should have known connects to that reasonable merchant line, because what someone should have known is what is the standard, the typical practices within a given industry. What we don't see defined in the paragraph is the word reasonable. What is a reasonable merchant? Or how would we go about showing what a reasonable merchant would expect in a particular condition? So here, when you're looking at cases, you're having to make decisions about, well, they found reasonable merchants in this case, but this case involved someone who was manufacturing shipping boxes. Here, it was also found to be reasonable for people in the practice of manufacturing coffee, right? But my case is about somebody who was selling horses. Is it reasonable within the horse industry? Would someone in our industry find this proposed amendment to be unusual or not unusual? So it's like going down from the largest level of abstract thought and continuing to pick it apart until you find the case that indicates what action counts as meeting that definition. And we start with a statute if a statute exists. But if a statute doesn't exist, or even when it does exist, we have to look for that definition as it evolves through the cases. So that's going to lead us to what I hope is our final few minutes of conversation, because we kind of got robbed at the end of session webinar number 2 of sort of that last moment to bring our thoughts together. So I wanted to make sure we had a few minutes to do that today. In the U.S. legal system, the way legal writers or what legal writers are managing is not only the Constitution, not only statutes and regulations, but also binding judge-made law. What is commonly thought of in civil law systems, but the extent to which it's true or not true in your legal practice, constitutions, yes, statutes, regulations, yes, there are judge decisions, but they are not binding. Right? Whereas in the U.S. condition, they are equal law. Often students who are starting to explore what legal writing looks like in the US, they struggle to understand, why do I have to read all of these cases or judicial opinions, whatever you want to call them, right? And it's actually, as I said before, not because they are examples of the law, but because they in fact are the law. It is within a case that you can find the legal rule, whether that rule started as a statute, whether that rule is a judge-made rule that helps interpret the statute and apply it to the facts of the case, or whether it is a judge-made common law rule altogether with no statute. Okay, so today our examples look at 1 and 2, and next week when we are talking about the IRAC plan, we will be looking at category number 3, which is a judge-made common law rule in the absence of a statute. I'd love to hear some reactions about how similar or different the system is to the way legal writing works in your context.
Okay. So while we're waiting for the comments, Heather, would you please explain one more time the word binding? Because that can be a difficult word to understand.
So something that is binding in the US means legally required.
Okay,
for example, if we go back to our early example about the airplane, and the airplane was not considered a motor vehicle. If any other airplane had been stolen, right, it could not be prosecuted under the motor vehicle statute. The Supreme Court, it was appealed, and it doesn't have to be a Supreme Court decision. It's just whatever the highest court is within that band of jurisdiction, right? So it could be at the state level, or it could be at the appeal level, but wherever the highest court decision is, that then becomes the forward-facing, binding, required, that is the law until it is changed in some other way, such as a revision to that statute. Right?
Okay, thank you. And we have a question for you here. What bodies issue regulations in the United States?
Because we have a federal and a state system, states issue statutes and regulations for their own states, and the federal government does it at the federal level. But each level has a variety of individuals and organizations that are part of that. So that is one reason why the ambiguity arises, is because there is no, I can't give you like one answer. There's not one Department of Legal Regulation writing, right? There's not one author. There not only is there not one author, there's not one body that has that sole responsibility for writing it. So it happens at multiple layers, but it's under the nomenclature, under the category of the legislature. But the congressmen and congresspeople, they don't themselves write every word of the document.
Okay, thank you. And we have 2 more comments. The first one is from Ella Jane. Statutes are more binding when they are forming or amending the contracts. And there is a comment from Alona. Though the judge's decisions are not binding in Russia, we still appeal to the judge's decisions in the court.
So we would call that persuasive law. So, for example, and you might have to remind me, because I had a thought related to the first comment, but I've already forgotten. Oh, no, I know. So the first comment was about, in the U.S. system, statutes are not more or less binding than case law. They are equal, right? You do, as a matter of form and organization, state a statute if the statute exists, but it is not persuasive. It is not law. If you were to only provide a statute as your legal logic, then you would not be found to be a credible writer, a person of credible authority in the U.S. legal system, because you are basically saying, I haven't bothered looking into the case law. I'm only relying on the statute. So they are one cannot stand without the other. Then the second question was about the similarities. And I was going to say, persuasive, yes. So in the U.S. context, you can bring in other information for the courts, especially if in tort cases, there's a lot of unwritten law. And if there's a new condition, you might argue by analogy. Like, you know what? I've done the research. We don't have a statute for this in the state of Virginia. The case law is absent. This is like, we haven't really explored this issue in the court system. But if I look over at Kentucky, this is the way Kentucky did something. That is not binding. A judge could say, I don't care what Kentucky did. We're not Kentucky. We are not obligated to follow that rule. Or the judge might say, well, I think Kentucky might have figured that out in the best way, right? So it can be persuasive to pull information from other sources, even other cases, but it is not binding unless it's within the direct chain of jurisdiction of that issue, whether that's at the state level or the federal level. All right, everyone, I hope that tonight brought you something interesting to chew on, to think about as we continue growing up in our understanding of legal writing, at least in the U.S. context, and understanding how legal writing happens, why it happens the way it happens. And from my perspective, if you use the logic of definitions, it can help you understand how information is being organized and why you see the type of information that you see in the paragraph. And it is a way to understand how legal English writers demonstrate what their legal logic is. And I do hope I see you guys in 2 weeks. We will be taking a look at something called IRAC as another way of organizing legal logic.
Heather, thank you so much for this logical explanation of this webinar. And I think on behalf of everybody, we would like to say thank you to you one more time. And so if you haven't signed up for the practical part, then we have to say goodbye to you. But if you have, we will see you in a minute. Please use the link that you received, and we'll be there very soon. So goodbye. So the next session will be on